And joining me on the show for an exclusive conversation is Arun Kumar, who, as the Joint Director of CBI, headed the CBI's investigation team into the Nithari case. Arun Kumar, really appreciate your time. Very strong words coming in from the Allahabad High Court. It has gone on to say that prosecution failed to probe organ trade angle. There has been casual manner of arrest, recovery and confession. Where did the investigators go wrong?
Thank you, Maria. Good evening. Basically, I've been drawn from a deep slumber as far as investigation of these cases are concerned, because I have changed department after that. But I have hurriedly gone through this decision just right now. Let me explain the things in perspective. There are two accused. One is Surinder Koli and another is Moninder Singh Pandher. As far as Moninder Singh Pandher is concerned, the line of investigation of CBI has been vindicated by this judgment. In case of Moninder Singh Pandher, we said that he had no knowledge of any murder of any of these particular accused. We had charge sheeted him only for 201 destruction of evidence and immoral trafficking act, where he had used some prostitutes and things like that. Other than that, we never said that he had any knowledge of the murder, and we never charge sheeted him for any case of murder and all that. But in one of the cases, I remember that the lower court suo moto made him the accused. And the day when he was in Australia, when the murder was committed, he was convicted that particular case. And the logic given was that that was the vicarious liability based on he is being convicted. So the concept of vicarious liability doesn't arise as far as the criminal cases is concerned. It's only for the civil cases. So such default has been done, and this particular conviction of Pandher was retracted again by the High Court in that particular case. You know that there are 19 cases. So in different cases, different set of judgments are coming. And in these two cases where the Moninder Singh Pandher has been acquitted, that is in continuation of the line of investigation that was done by CBI. So no problem in that. Now coming to the case of Surinder Koli, I would like to remind you that in one of the cases out of these 19 cases, Surinder Singh Koli has already been convicted by the trial court, by the High Court, even by the Supreme Court, by the same set of evidence, by the same so-called bust up investigation. And in this particular case also, honorable judges have compared those convictions with their independent finding, and they have made compare and contrast in that particular case. Now it will be certainly of the Honorable Supreme Court to see that whether their reliance on these set of evidences, the previous case where Surinder Koli was convicted, was right, or this analysis of Honorable High Court in this particular case will stand. So that is something different.
Okay, now, but Mr. Arun Kumar, one question that is on everybody's mind: who killed those 22 women and children?
I'm coming to that. So I am telling that out of those 22, one or two who were killed has already been convicted that Surinder Koli killed them. This has been vindicated by Honorable Supreme Court also. For that case, he has already got the capital punishment. So now the question is that about this set of cases, so you don't club all the 22 cases together, because one of the cases Supreme Court has said that Surinder Koli killed. That's clear, final. Now, since 22 other cases were tried separately, and the same evidences have been produced, so this is a set of observation by judgment by Honorable High Court. Now, I would not like to comment on the various aspects of this judgment, but some of the few things I would like to certainly mention here. The main thing, as you said, that the part of the organ trade was not investigated properly. Now, after 17 years, we know that how the organs are being replaced and how the organs are being removed and being done. So if we are going would have find that the organs being traded, the liver and the kidneys will be found in the nala, how we could have proceeded in that particular case. In some of the points I would like to raise, that the Honorable Court has said that the confession of Surinder Koli has been made in a particular ACMM case. He being a seventh pass person, how could he have known that he is going, the application is to be made to the ACMM court? Now, this is very surprising that if a person is not literate, on behalf of his an application is written by somebody else, he is asked to read that particular thing, and he is asked to sign or give his thumb impression, and on that the things is being proceeded. So why should there be any doubt that how do he know that in which case the confession is going to be?
Allahabad High Court is saying, Mr. Arun Kumar, that the investigation was botched up and basic norms of proof collection violated. So is the CBI actually not able to investigate? Were you not able to do your duty or your job only because the UP police did not do its part initially?
No, that part is already there, but I am already telling you that by the same set of evidences, Surinder Koli is already convicted, number one. Number two, if we come to the ingredients of this particular judgment, the judgment starts that he was arrested 2 days before and he was shown arrested by UP police 2 days later on. Now, it depends that when you see a person or start talking to a person, you take him to the police custody, you move there and show a formal arrest after a few hours. When the CBI takes the case, they separately arrest the person. I'm just showing the technical grounds on which this particular case has been acquitted. That was the ACMM application case, was another evidence to say that how technically the set of confession, the CD on which the confession was
so
recorded.
when you're talking about technicalities, my question is that did the CBI not build a watertight case then?
It was perfectly watertight case. My point is that the honorable judge has doubted that he was kept in the 60 days in the police custody, so he must have tortured and his medical was not done. This is absolutely not true. The medical examination of Surinder Koli has been done obscene number of times when he was in the custody of CBI. So was that medical evidence not produced before the court? I am not sure.
Okay.
And if that's so, that must have been produced, and not even a single injury was reported anywhere. So there is no question of any confession based on duress. So these are the observation I was talking about. Honorable judges said, just a minute, honorable judges said that events mentioned in the case is highly improbable. Certainly it's highly improbable. And that was the reason that we had circulated this particular case to all the Interpols of the world, and only South Africa has said that one case has been reported. So it was certainly very, very improbable case. So what's wrong? Everybody knows that's very improbable. The court says that when Koli was brought on the scene of crime, the digging was already gone. So the recovery based on Section 27 has also been doubted. In case of the recovery of a pistol, recovery of some opium and something can be planted. Can organs of human being be planted like this at the house of a particular person, so that you doubt that the recoveries are not correct?
So let's see what CBI's next move is going to be. Thank you so much for your time, Arun Kumar, and explaining the position of the CBI.